communique issued by the Rivers State National Assembly Caucus. Gentlemen of the press, we have invited you this morning to extinguish the delusion, prevarication, lies, and deliberate distortion of facts and judgments of court as it affects the Rivers State House of Assembly under the leadership of Right Honorable Martin Amehule, the Governor of Rivers State. This has become very necessary as the governor has procured the services of some persons, including senior advocates of Nigeria, to turn the law and judgments of court upside down, to skew public opinion to align with the governor's position and give him a reason not to obey any judgment of court that is against him or not in his favor. We wish to caution Mr. Femi Falana, SAN, to stop misinterpreting judgments of courts. It is regrettable that a very senior lawyer of his status will be amplifying the falsehood from non-lawyers and political merchants. Falana lied about the dates of the judgment of Honorable Justice J.K. Omotosho and the purported defection that never took place with the intention of misleading the public. We wish to warn these false content creators and political merchants that it is very possible to continue to eat from the treasury of Rivers State without tampering with the position of the law and the intentional misinterpretation of judgments of courts. For the records, there were several reliefs aside from the presentation of the 2024 budget sought by Right Honorable Martins Amehule led assembly before the Honorable Justice J.K. Omotosho, which included the determination of who is the Speaker and members of the Rivers State House of Assembly, non-interference by the Governor of Rivers State with the activities and functions of the Martins Amehule-led Assembly, protection by the Inspector General of Police to ensure adequate security for them to carry out their duties, and the disbandment of any other House of Assembly in Rivers State or self-acclaimed Speaker other than Right Honorable Martins Amehule and the 27 members. All the reliefs sought by Right Honorable Martins Amehule were granted by Honorable Justice J.K. Omotosho on the 22nd of January 2024. We hereby produce the orders of the Honorable Justice J.K. Omotosho as affirmed by the Court of Appeal and the Supreme Court. We refer the press to pages 6 to 16 of the judgment. It's instructive to state emphatically that by the withdrawal of the governor's appeal before the Supreme Court and the dismissal of the suit with cost, the judgment and all orders made by Justice J.K. Omotosho, which was upheld by the Court of Appeal, takes effect immediately and forever. This, of course, includes the affirmation of Right Honorable Martins Amehule as Speaker and the 27 members of the Rivers State House of Assembly as the only House of Assembly of Rivers State, and the directive to Inspector General of Police to provide security to enable the Rivers State House of Assembly to continue to perform their functions without hindrance. We wish to call the attention of the Governor of Rivers State that in his notice of withdrawal before the Supreme Court, he rightly referred to Right Honorable Martins Amehule as the Speaker of the Rivers State House of Assembly. Therefore, there is no more contest as to who the Speaker of the Rivers State House of Assembly is, and any attempt to continue to deal with any person or forum as the Rivers State House of Assembly is not only contemptuous of the judgment of the Supreme Court, but a direct call for political anarchy or social lawlessness. The shameless and contemptuous actions of giving any assignment whatsoever to anybody purporting same to be the Rivers State House of Assembly other than Right Honorable Martins Amehule-led House of Assembly should stop forthwith. The Governor of Rivers State, having failed to use the Court of Justice Wali to unseat the 27 lawmakers, has initiated a plot at the Federal High Court in Rivers State to declare the seats of the Right Honorable Martins Amehule and the 27 members vacant, even when the Federal High Court, Appeal Court, and the Supreme Court have all affirmed Right Honorable Martins Amehule and the 27 lawmakers as the only Rivers State House of Assembly. We are calling on the executive arm to execute the judgment of the Court of Appeal, affirming Right Honorable Martins Amehule and the 27 lawmakers as the only Rivers State House of Assembly to avoid any breakdown of law and order in Rivers State. And this communique was signed by Rep. OK Chinda, DSSRS Minority Leader, Senator Bariada Mpigi, DSSRS National Assembly Rivers Caucus Leader, and Right Honorable Dunamene Deko, DSSRS Leader, River State Caucus House of Representatives. Nze, what do you make of this communique?
Honestly, as a person, because by God's grace I have I've always stood on my opinion. It doesn't matter how much you preach to me. If you convince me, I get convinced. If you don't convince me, I can't say one thing through my mouth and have another thing in my heart. That is the way I live. Do you see this communique by this few? I see it as a kettle calling pot black.
How do you mean?
They have their stand, and the governor has his stand. They are standing on their stand, accusing governor of not standing properly. And from governor's standpoint, he is seeing them as not standing properly. So what they are accusing the governor of is what the governor is accusing them of. So they have just said their own mind, expecting governor to also say, if governor and his caucus will also come to give their own communique, you still see that the two will never align.
So what is the governor's standpoint?
Now, no, before I go to governor, I can't say governor's complete standpoint on this, except to say that everything they enumerated here, governor is against them.
All right.
All.
Okay.
And look at where I have issues as a man, as a Nigerian, where I have issues with the caucus. And I feel bad that Honorable Kechinda should be involved with this. I feel bad. I can forgive Barin Piggy. I can forgive Deko. But Okechinda, I have respect for him, honestly. And seeing him speak in this manner, I say, well, Oga, well, let us dismiss you with the same feeling that them, the politicians, who can't see truth and call it truth.
Okay.
Look at what they wrote there. Because for him to append his signature means that he read it, he understood it, and he believed it. He said that the defection of the 27 lawmakers never happened. Okechinda telling Rivers people and Nigeria and the whole world that what they watched never happened, thereby making us believe that we were all sleeping as at the time we saw what we saw, and it all happened in the dream world. No wonder Zebodiah was flogging his daughter Philo, because Philo was beating the man in the dream. So when he woke up in the physical, he now started beating the girl for maltreating him in the dream. So Okechinda is trying to tell Nigerians that all we saw, the defection we saw, the songs that were chanted, the reception that was granted by the APC chairman, of, if I may call him factional chairman as at then, all those things, even reception by the president and commander-in-chief of Federal Republic of Nigeria, Chief Ahmed Bola Tinubu, who received these people and made a statement that they are my children, I will not chase them out. Now Okechinda is coming to tell us that those things never happened. The
president never, you can't quote anywhere. This statement you made last, you cannot quote anywhere that the president made that statement. You could say that was the word on the street. But to say that the president said it publicly,
well,
you can't quote that.
Well, but if that is the
but,
word,
but then,
if that is the word on the street, but we know that the president received them.
Hold on.
And he called them
hold on. But then, because I want us to look at the matters they mentioned in the communique, one by one. But you have first addressed the issue of the defection, which they are saying that these lawmakers never defected. Now, I am not going to look at it from the angle of emotions. I'm going to look at it from the angle of what the law says. Okay. Because this is actually what the court will consider, not our sentiments or our emotions or what we feel, but the law is going to look at the facts before it, and the law is going to look at constitutional provision, right? Now, the question I want to ask you is this. Can one say that this Martin Samehule and the 27 lawmakers, can one say that they are indeed members of the APC? Do they have the membership card? Are they in the membership register? Did they participate in the congresses? In recent time, the congresses that were the controversial congress that was held sometime last year, did they participate in the congresses? Have they been attending APC meetings? Have they been speaking as APC, or have they been carrying themselves as APC members so far?
Yeah, you know, something happened, and we need to understand that. I'm happy that we're having this conversation devoid of emotions and sentiments. Rather, we are looking at it from our perspective, our personal perspective. You see, that movement wasn't the right one. That issue of defection wasn't the right one.
I don't understand what you mean.
I mean, the attempt to defect, leaving PDP.
Are you saying it wasn't correctly done?
I said it wasn't a right step to take in the first place.
Okay.
Now, but either by, if I may say, deception or oversight, whatever prompted them to decide to leave PDP to APC when the crisis just came up was what I cannot tell. But look, there is a law, there's a provision. And we know that in Nigeria, we have a way of doing our thing. I once had a girl who was in her final year, but was having a lot of carryover. Now, this same girl went back to lecturers, sorted some issues out, and graduated and got her certificate without going to resit those exams. These are things that happen in Nigeria. You know that somebody can say today, I am no longer a member of APC. I have joined Labour Party. And by saying it, Nigerians will see him as a member of Labour Party. Then he can now begin to go back to fulfill the requirements after declaring his stand. He can now go back to fulfill the requirements. The membership registration, the membership card, and payment of annual dues and things like that.
Now, I have spoken to a member of, I've actually interviewed a member of APC State Executive Council on my show on several occasions. And I have asked, now when I say APC State Executive Council member, now on the side of Tony Okocha, and I have asked severally, because that defection happened when Tony Okocha was the caretaker committee chairman of APC in Rivers State. He wasn't factional. He was the caretaker committee chairman.
Because the court has not given judgment by then.
Hold on. He was the caretaker committee chairman of APC in Rivers State. So the register of the party was with him. And I asked the State Executive Council member over and over, are they in the party register? He said no. He even mentioned one of the 27 lawmakers that, you know, that comes from his constituency, and said, I have never seen him but at the word nothing. That he is privy, he has access to the register, and he's telling me he's not in that register.
Can I tell you something?
Now, hold on. That's on one hand. Now, on the other hand, the Emeka Beke-led APC faction, I have also had the privilege of, you know, interviewing one of his State Executive Council members, and the man said that he is not in Emeka Beke-led faction party register. That in the first instance, that defection did not happen under Emeka Beke. And Emeka Beke is not privy to the contents of the other, but for their own register that he is aware of, that they are not members of APC. You know, Emeka Beke cannot lay claim to them because he does not have them he's in the register that he has. Right. And I have also interviewed a PDP member here in Rivers State who is also privy to the register, and he said these people are in PDP register.
Yes.
Isn't that the conundrum? Because now, if the court now is to look at facts, one would say there was something was televised. Now, the people that did it say they did not defect, and they are giving that activity another name. Now, what is the constitutional provision for defection? It was not fulfilled. Can an affidavit translate to, because what the Constitution actually says that will be read on the floor is a letter of defection, not an affidavit. And the letter has to be individual, not a group. Now, I'm bringing out these things because these are the facts on ground that one would have to consider.
Yes.
So, before we move over to the next point that was raised in the communique, what do you have to say to that?
The truth is this. If truly we want to, handle this thing from a neutral viewpoint, one would say, what you said is what I'm judging you by.
Does that
not what you do, not
statement,
what you do.
This statement now,
yeah,
can it stand the test of time in court?
Now, I am not a judge, but if I go, I'm not a judge, I'm not a lawyer, but if I go to court, I will make my statement. And I believe that it is the statement I make that lawyers will interpret, judge will look at, and give his judgment. So, if there is action that should take place, the first action will be the action of the word. And we saw, like what I expect, in as much as I still believe strongly, let me tell you this, let me make this thing very categorically clear, that Governor Similar Fubara is sitting as the governor of Rivers State does not add anything to me other than the society. That Martin Samuel Hule is removed from Rivers State House of Assembly does not remove anything nor add anything to me other than the society. So the issue, the contention there is theirs. I'm only discussing it to first keep myself on my own right sense of reasoning, and as well make my viewers also reason from my angle. I'm coming to the question. My point here is what the courts will use as their basis for deciding that judgment is left for the court. But to me, I would suggest let the court base their judgment first from what the man said before going to what the man did.
If you say what they said they didn't defect.
No. I'm saying we have the picture, we have the videos. Let those evidences be
now
brought
you're talking
before
of
the court.
evidences. Do these things align with what is obtainable in the Constitution? Let me make it more pedestrian, right? And I will use you as an example to drive it home. Now,
why using me?
Because it's more relatable.
Okay.
So now, Nze, your name is Nze, your surname is Nze, correct?
Yeah.
Now, and while we are on this show, I arbitrarily tells people that, oh, I'm Mrs. Nze. It's a pleasure having my husband on the show today. Immediately you revert, you say, I am not your husband.
If I want to.
If you want to.
Yeah.
Even if you don't want to, right? The fact that I said it on air, said it to the world, but traditionally, my parents, my kinsmen do not know you. When it comes to the law does not recognize whatever it is we are doing. In fact, even if we are living together, the law will call us living lovers or partners. But we are never, before the law, a married couple. We are not, right? And you can choose, after 20 years of living with me, to go and marry someone, do the traditional rites, take that person to court. I cannot lay any claim to the legality of my relationship with you because the law, according to the law, there was never a Mrs. Nze prior to that marriage. Whatever it was I was saying cannot be authenticated.
Fine. Let me respond to this.
Go ahead.
you know, you just painted a picture. Let us use that picture here.
Go ahead.
You have come on air and announced that you are now this person. And somehow, by that announcement, all the viewers all over the world, this is Mrs. Sinze, this is Mrs. Sinze. Anywhere they see you, whether you mention your name or not, they will help you to mention your name as Mrs. Sinze. Yes, we have not really come to your family to see your people, to carry out the rites and all those marriage rites and stuff, or taking you to church for wedding and things like that. But now we begin to cohabit. Now there is something else we need to understand here. Nature will place its own judgment. And what is the judgment of nature? The both are now living together, like or as, okay, let me say like husband and wife, not as husband and wife, but like husband and wife, because originally they are not. But now they have started producing children. Remember, you have said, I am this, and both of you are living. But before the law, you are not. And you have given birth to children, and the children grow to see you as their mother, me as their father. Even without marriage, to the children, we are legally married. To the children. Then to law, we are not. To your family, we are not. To my family, we are not. But to the children, we are. And it is these children that will carry on our life here on earth. That's why I'm saying that whatever judgment the court will give on this matter, the matter has produced children. And what is the children?
It still boils down to, you see, it still boils down to what I asked you earlier. If in the first instance there were no issues, we could even live like that, die like that.
Yeah, yeah.
But now, when there is a contention and the legality of whatever it is we have is brought into question, and it is being x-rayed, right? You will find out that whatever it is we have had no foundation whatsoever. Now, the law does not stop you from being the biological father of the children. In fact, by the law, you'll be mandated to take care of your offspring. But remove the law is not concerned about the kids. The law is concerned about the authenticity of what we have claimed to be. That the law is oblivious of. The law does not recognize. That's why I'm asking these questions, because everything everybody has to say about it is emotions. Everything anybody has to gloat about it is sentiments. But when it comes to the law will not consider that we have spent the better part of our youth together. The law is not going to consider all of that. The law would say, as long as I am concerned, both of you do not exist as a couple, as husband and wife. The same with our kinsmen. God forbid something happens along the line, I die unmarried to you. In the Igbo tradition, you know what the implication is. And that is when the family of the woman will not tell you will marry her corpse, because in the first instance, they do not recognize you. And again, even when they are doing things where husbands will come and participate, you cannot come.
Now,
the embarrassment and the shame.
There's something I want to add to this.
The embarrassment and shame of your illegitimacy will not let you show face when men who legitimately married their daughters. But that's a fact. Now, and when you stand to talk, they will shut you down.
There's something I want to pick up from here.
Go ahead.
If maybe after 15 years of cohabiting, and having produced offsprings, male and female, and an issue occurred, and I now say, no, we have never married for once. Or you said, no, we never married for once. I have such case on my table too. Now, I go and marry another woman and produce offsprings from that woman. Will the children of that woman who was married legally take precedence over the children of a woman who was not legally married?
In the first instance, Nze, this is a complete deviation from what we are talking about. Because
but we are painting a picture.
No, the picture is completely off. You know why? we are not discussing the children, the offspring. We are discussing the legality of the marriage. So going ahead to bring in the branches actually does not hold water, because what we are talking about is, did these people legally defect or not? And whatever defection we are talking about, we are not talking about any offspring of the defection, because as at now there are
already the defection have produced offspring.
But then hold on. But then let us move on to the second point that was raised in the communique, or the first point actually that was raised in the communique, and that was the National Assembly Caucus calling out Femi Falana, SAN, for allegedly misinterpreting the Supreme Court judgment, right? And you know that when Femi Falana was speaking, he predicated, or he narrowed down that judgment to one thing, one relief, and that is the 2024 Rivers State budget. What do you have to say to that?
Good. Femi Falana had been called a liar and a misinterpreter of the judgment of the Supreme Court by the Rivers State Caucus. I know that at one point or the other, either directly or on proxy, have some of these people engaged the services of Femi Falana, SAN. And either they have secured judgment through his dogged legal approach as a lawyer. But seeing this one that happened now, Femi Falana has spoken his mind, and they now come openly to tell the whole world that Femi lied by the way he interpreted the Supreme Court judgment. But there is something that we need to look at.
Go ahead.
Femi Falana said that the reason why the governor withdrew his appeal was because the judgment is hinged on 2025, a presentation of 2024 budget, and by their understanding that time has overtaken the event of 2024 budget, and nobody can ever reverse it. And for that reason, the governor had to withdraw that. Every rational man, including me, who is not a lawyer, looked at it from that angle, because when they were telling us on 13th of February, is it 13th of February, the judgment of Supreme Court, I asked a question. Some of the people that were discussing with me, I say, what if Supreme Court comes to say that Martin Samuel Hule is the authentic speaker and the governor should present 2024 budget to him? Who will travel back to 2023 December and reinvent everything and present that budget? Who will do that? Nobody will. And now, if the governor and his team of lawyers have looked into this matter and know that time has overtaken that action that is in court, for that reason, they said there's no reason for us to keep wasting the time of the Honorable Court. We withdraw this because it has happened. It has happened. It's like, for instance, me and you are quarreling over this cap. Who should wear it? The cap is not my own. It's not your own. But the cap is on the table, and we have come here. Somebody must wear it for us to talk. And we are quarreling over it. And the matter is in court. And it is compulsory that someone must wear this cap on this table. And along the line, while the litigation continues, I die. I think the court will be right in their mind to continue to judge. If at the end of the day they give me justice, what happens? Will I be here with my head, or will they go and bring me from my grave to put me the cap? Now, once it comes like that, the court will say, okay, since the other partner is no more, let the one that is alive wear the cap.
All right, very well.
So Femi Falana, by description of the caucus, Rivers State Caucus, had not in any way faulted or even told any lies. He simply said what he felt was right, and he's entitled to his own.
It's also important to note.
He's entitled to his opinion.
Hold on. It's also very important to note at this point that Femi Falana is an interested party in this matter. I hope you're aware.
Yeah.
He's an interested party, and he's a counsel to one of the appellants.
Okay.
Counsel to the Rivers State government, actually. So would you expect Femi Falana to speak otherwise?
if he has spoken otherwise, and we don't like
when
it,
he is a counsel,
yeah, if he had spoken otherwise,
his job is to protect the interest of his clients in this instance,
and that he's doing
in this instance.
So if these people come to call, say that he's speaking lies by protecting his client,
let's look at other
see the angle where this
now.
People are
When
coming
you
from.
the thing is this: when you take a matter to court, and the court is giving judgment, the court will give judgment according to the prayers presented to it. You cannot say you cannot select the judgment to obey and the judgment not to obey, because I mean it comes consolidated, it comes as one, right? Now, in this instance, Femi Falana has thrown away other reliefs that were granted by the court and singled out the 2024 budget. Right. Now, let us look at the reliefs that were sought. It said, apart from the 2024 budget, Justice J.K. Omotosho included the determination of who is Speaker and members of the Rivers State House of Assembly. That was part of the judgment. Justice Omotosho declared that Martin Samehule was the is the legitimate Speaker, and the 27 House of Assembly members are the legitimate members. He also said that in the judgment that was passed, the judge also ordered non-interference by the governor of Rivers State with the activities and functions of Martin Samehule-led assembly, protection by the Inspector General of Police to ensure adequate security for them to carry out their duties, and the disbandment of any other House of Assembly in Rivers State or self-acclaimed speaker other than Right Honorable Martin Samehule and the 27 lawmakers. Now, this was part of the reliefs that were granted by the court. The implication of withdrawal of that matter from court is that the Rivers State government has accepted the judgment of Justice Omotosho. I hope you understand.
I don't believe that.
Hold on. That is, you can actually go and verify.
No.
Hold on, Nze.
Okay.
That is the implication of that singular action. Withdrawing a matter in the first, which was the first mistake that was made as well in the matter of justice, in this judgment by Justice Omotosho. Recall the governor went and withdrew his counter affidavit. And then the judgment came that was not favorable to him, which he appealed. And if you recall the judgment of the appeal court, the appeal court did not spare the governor. The appeal court was very harsh in its judgment, actually. The appeal court held the governor in contempt of court. The appeal court, when addressing the governor, told him that you cannot appropriate and reprobate. Just you cannot appropriate and when you withdrew the counter affidavit, you waived your right over a matter. These are fundamental legal issues that anybody should know. So now, in the Supreme Court, the same thing plays out again, where the governor withdraws his appeal. Now, he's withdrawing the appeal based on one relief, and that is the 2024 budget. Question is, how about other reliefs that were granted by Justice Omotosho and upheld by the appeal court? Let me give you a sentence that the appeal courts made in their judgments with regards to the speakership of Martin Samehule. And I quote, the appeal court said, in the issue of the speakership of Martin Samehule, it is not in contention. That's the statement of the appeal court, that the speakership of Martin Samehule is not in contention. So, moving forward, how do you think the governor can go around these other reliefs that was granted by Justice Omotosho and affirmed by the appeal court?
All right. Let me tell you that it is one key, only one key, that will be used to open all these reliefs put together. And that key is the authenticity of the membership, the legitimacy of the membership of Martin Samehule and 26 others in the Rivers State House of Assembly. Now, when was that case instituted in the courts. That's what every right-thinking, rational man should consider.
Okay, go ahead.
I'm coming. When was the case instituted? Number one. When was Amwehule? When did Amwehule and his group defect from PDP to APC? Number two. Number three now. When did Edison here declare their seat vacant? You see that the litigation came first. The institution of that case.
When did the judgment come?
The judgment came January.
Did it come before or after the purported defection?
You are the one who told me here now in our discussion that court does not grant a prayer that is not brought before it. Now, by the time Amwehule and his group went to approach Justice Omotosho's court, they were still members of Rivers State House of Assembly. And Omotosho, to me, was not wrong when he declared that Amwehule was still the substantive.
Okay, now let's look at the time. Let's look at the timeline so that you add it up. This matter was instituted November, I think 11th of November.
No, 29th.
29th of November, yes.
November.
Now, the defection, the purported defection, happened in December. The judgment came 22nd January. Now, if the suit was instituted in November and the alleged defection happened in December, the governor had ample time in his counter affidavit to raise the matter of that defection, and they declare and also praying the court to declare their seats vacant. The governor waived that right.
Now,
let's get these things clear.
Yes.
Because when people say when people say it's a post-defection matter, a pre-defection matter, I now ask, within the lifetime of this litigation, this entire activities has happened.
That's why I told you, let's take it one by one. Let's take it one by one.
Would one say the judgment was not apt? Because as at the time the judgments came, the alleged defection had happened. Now, the governor in his counter affidavit could have raised up the matter of that defection. The court will still adopt it. Even if the court is in process, you could still raise that up. It will still be adopted.
Let me respond to this.
Go ahead.
Because we are looking at the time frame now. Let us assume that the matter was instituted on 29th of November. And by 11th of December, they defected. And Edison here, in that same December, declared their seat vacant. Now, the governor filed his counter affidavit against that litigation. Now, the governor is supposed to stand in court with Amwehule faction and himself. But something happened. They all went to Abuja. Before the judgment, remember, they went to Abuja. And part of the 8-point agenda Mr. President gave to them was go and withdraw all cases. They didn't say some cases, they said all cases in court. Go and withdraw all cases in court.
Go ahead.
And now the governor returned back. We saw that immediately. In fact, I first saw that 8-point agenda on social media. And I called some of my friends and we started discussing this matter. I was angry over that. When I read it, I said to myself, I don't want to mention names on national television. Names of the people we were together with, I was together with. And I told them that this stuff was written by one man and given to the president, and the president used his power to force others to sign it. Now, I don't care whether the governor was forced or he was not forced, he was coerced or was not coerced, but he signed it and he returned home. And he started applying some of the things that Mr. President had put in that 8-point peace resolution. And one of them was to withdraw his counter affidavit from that law. To withdraw his counter affidavit from that litigation.
Yep.
And he did. Which, if Honorable Martin Samuel and his group were to be honorable enough and obedient to the instruction of Mr. President, they should have also withdrawn that case. But the governor withdrew his counter affidavit.
And they withdrew their impeachment notice. I'm
coming to an impeachment or whatsoever. I'm just talking on this judgment.
Right.
So the governor didn't just on his own withdrew his counter affidavit. He withdrew the counter affidavit on the instruction of Mr. President. And this other group did not do theirs. They left it. And that was where the Justice Omotosho didn't bother to know whether you withdrew it because President asked you to.
Now,
Justice Omotosho said that you withdrew it.
Very quick question. What did the government premise their withdrawal on? When they were withdrawing that matter from court, did they tell the court, we are withdrawing this matter because there is a presidential peace pact?
No,
the court, to a large extent, one would say the court to a large extent is unaware.
Fine, I like the word you use.
No, hold on.
I like the word you use.
Hold on, so you understand the trajectory of my thoughts. Now, one would say the court is unaware of that because what you say to people does not apply in the court. What was the reason for withdrawal? At no point, that the council of the governors or the River State government come out to say this matter was withdrawn because of the peace pact. Now, it was not said. So I will not consider, if I am the court or even as I am here speaking, I will not consider that this was what happened. What I am looking at is what was the reason for the withdrawal. The peace pact was not quoted as a reason for withdrawal of the case from court. But the point is this: when the argument of post-election, post-defection, and pre-defection comes in, one would ask, from the time this matter was instituted in the Court of Justice Omotosho to the time the judgment was given, both the post and the pre happened. Now, Edison Ehe, on the other hand, that you are saying declared their seats vacant, the question would be, Edison Ehe was suspended and never challenged that suspension. Both Edison Ehe, Okojombo, Sokari Good Boy, and one other.
Did he accept the suspension?
No, hold on. You cannot say did he accept the suspension or not. If he did not accept or they did not accept that suspension, the question would be, was it challenged in the court? It was not challenged in the court.
Good.
Now, how can you build legality on illegality?
Good.
Do you understand? With what constitutional power did Edison Ehe emerge as the speaker from suspension to suspend?
Let us build our thoughts on this.
That's the thing. And then finally, before we wrap up, I want you, like I asked you a question that you never answered me, Nze.
But can we treat this before I come to that last question?
I will still ask you so that you will not remember. The question that I asked that you did not answer was, I asked, how is the governor going to get around the fact that by the reason of the withdrawal of his matter from his appeal from the Supreme Court, the judgment of Justice Omotosho is binding on him? And it's not just limited to 2024 budget, but other reliefs that were sought. How is the governor going to get around this, considering that he has continued to, govern with Okojombo?
Good. That's why I said I will come to that.
Go ahead.
Just remind me, I believe we still have a few times. But first, let's wrap our thought around what you said here. In the eyes of Justice Omotosho, because the governor's lawyers did not tell the reason why they were withdrawing their counter affidavit, Omotosho does not know why. He only knew that affidavit was withdrawn.
Counter affidavit was withdrawn.
Are you getting me?
Go ahead.
The same way, Justice Omotosho does not know that a matter that is before him, that the person who brought a matter before him has lost his legitimacy. Because as at the time the matter was brought before Omotosho, the legitimacy of this man as a member of Rivers State House of Assembly was intact. So what happened after the establishment of the litigation does not appear before Justice Omotocho, just as what prompted the governor to withdraw his counter affidavit was not mentioned to him, if that be the case. So now look at it. He gave his judgment. Now, governor suddenly ran back to appeal. Appeal court lashed him because you can't, how do you put it? Approbate and reprobate. Mm-hmm. And he was lashed on that. He now ran to Supreme Court and said, Supreme Court, see me. And while they were waiting for Supreme Court to handle the governors, the Supreme Court delayed until time overtook it. Now let us come to the area of other things that the judgment of Omotosho granted. That the Martin Samuel Hule, that the governor should represent the budget to Martin Samuel Hule. Mm-hmm. Unfortunately, Martin Samuel Hule was no longer a member, according to
who?
The governor, according to the assembly led by Edison Ehe.
Now the question is, when you know, hold on. When you say according to the governor, this is where the issue is. When you say according to the governor, according to a three-man assembly, what does the law?
I never called them three-man assembly.
The court called them forum of friends.
The court that called them forum of friends called them forum of friends based on the fact that they were still seeing that judgment from the point that Amoehule was a man.
Hold on, Nze. The governor became a governor by the law.
Yes.
Right? The law empowers him to act. If the law empowers him to act, then he should act according to the provisions and dictates of the law. It becomes a problem when we say it is okay for the law to be set aside and in the eyes of the governor.
No.
Hold on. In the eyes of the governor. In the eyes of the governor, in the thoughts of the governor, there was a judgment. In fact, if you go through the certified true copy of the judgment of Justice Omotosho, the representation of that budget was an order of mandamus. If you go back, and it was a mandate. Now, when you say time has overtaken it, doesn't it give room for impeachment and gross misconduct?
No.
Because recall that Martin Samuel Hule, on more than one occasion, or more than two occasions, have written to the governor.
As who?
To present, hold on. To present the budget, to represent the 2024 budget to them. The governor did not pay heed to them. And press conference, during their plenary, Martin Samuel also spoke to the governor and reached out to him. Now you are saying the governor chose not to do that because the governor does not recognize them in the eyes of the governor. You said in the eyes of the governor, they are not legitimate.
They are no longer
Is there any court of law? Is there any judgment or any ruling that the governor can quote to give life to his decision?
Now let me attend to this.
Yes, go ahead.
When power does not and cannot exist in a vacuum. When these 27 members made a mistake they made by moving to another political party, when their own political party does not have issue, because they try to look at the issue of secretary of PDP as this, but they couldn't substantiate it, so that's why they ran back. Now, by the time they left, these remaining 4 persons had to occupy. And you see that judgment, the Supreme Court in Nigeria had given judgment to issues like that over time. You see it in Plateau State. You see that even in Rivers State at some point in the time of Nyesom Wike, where...
Actually, when you say Plateau State, the Plateau State judgment does not favor the governor in any way. I hope you know that.
I'm coming.
The Plateau State judgment by the Supreme Court indicts Governor Similaye Fubara. I hope you are aware. So quoting it will not, anyway, go ahead. We are out of time, actually.
I am not holding brief for anybody.
Yes.
But I am standing on what I consider as truth. So you now see that if these guys have come to say these people do not exist, now they don't exist. So
which guys say they don't exist?
The assembly,
governor.
The assembly, not the governor.
Which assembly?
Led by Edison here.
All right, very well.
So Edison here said they don't exist.
Okay.
And now the Omotosho, who never knew about all this, because this Omotosho, he was looking at Amwehule as at when he was there. So now this thing that was granted in that court, in that judgment,
we are out of time.
Does not hold water.
All right,
so
very well.
As I speak, as I want to round and conclude by saying
we are out of time.
That what the Rivers State Caucus came to do is a deception.
All right, very well.
Ripping up sentiment
very
of
well.
the public,
Thank you so much.
We cannot accept that.
Thank you so much, Nze. We are out of time.